Could ask Chairman Rick Williams, would you mind saying a word, please, sir?
Thank you. Bow our heads. Dear Lord, thank you again for another day. Thank you for our many blessings and opportunities that you've bestowed us. Please bless this world, dear Lord. Bless our men and women in uniform and keep them safe, and our men and women in harm's way and at the border. Bless the people of Israel, and in thy name we pray. Amen.
Amen. Thank you. All right. We're going to have two bills. First, actually, is just a resolution. It's a very quick one, simply setting up a study committee for the disaster mitigation and resilience. Obviously, this is pretty straightforward on what it does. Chance for us to study it in the off session. Is there any discussion to the resolution? The bill's author is out. Oh, you're here. Oh, I thought you were not going to make it. My apologies. Come on down to the podium so all the folks at home can see you, Mr. Chairman.
Yes, sir. Thank you, Mr. Chairman. Sorry about that. Stuck in another committee, but this is Senate Resolution 751, and it does create a resilience study committee. As many of you know, we have disasters that happen across our state, and we dealt with this specifically back in 2018 with Hurricane Michael in my district, where we actually had to come back into session and have a special session to deal with funding and needs that communities had. And so part of this resilience study committee will be how do we as a state better deal with natural disasters and problems that we have in our state to plan before and to plan after, and how do we move forward. There are currently 13 other states that have already started an Office of Resilience, and so that's what it does, and I'll be glad to take any questions if there are any.
Seeing none, what is the will of the committee? Moved to pass from Senator Jackson. Got a second from Senator Goodman. You beat you. All in favor, please say aye. All opposed, please say no. Passed unanimously. Congratulations. Best of luck in the Rules Committee.
Thank you, Mr. Chairman. Appreciate it.
Thank you. All right. We're going to resume the testimony we had on House Bill 1105. I want to apologize again for the challenging scheduling we had yesterday. It was unfortunate that the legislative session went longer and we got exited from our room for other committees. We want to have everybody the opportunity to have a good, thoughtful conversation on this. We do have a committee substitute that is in the folders for all of you. I want to take a moment and thank the bill's author, Representative Petrie, and Jenna Dolday, our legislative counsel, and everybody who worked on this together. So we're going to pick up where we left off. I'm going to ask Sheriff Ron Freeman, good friend, to come up here to the podium, and he's going to use the last remaining few minutes for law enforcement before we go into those who are opposed and those who are for the bill. We're going to wrap up with the bill's author, who will explain the handful of changes that are in the bill, and I think we've got a couple of minor amendments as well for cleanup. So, Sheriff, please.
Thank you. Chairman Albers and members of the committee, thanks for having the sheriffs back again today, Sheriff's Association back. Thank you for working with us on it. I think a lot of the comments that I would have made, I think we've been able to work through, and I appreciate this committee working through some drafts with us and some suggested language. If I can say in closing one thing that I want to make sure that's resoundingly heard from the committee and that you understand. Sheriffs across Georgia are committed to fighting against crime and fighting against folks who endanger our community, and we do it every day. Make no mistake, the challenges that are here are with our federal partners. The chairman can share, if he chooses, just the challenge that we had. In earlier meetings with Chairman Albers, we attempted to set up a meeting with the Department of Homeland Security, the Enforcement and Removal Office. And that was simply not about politics. It was not about anything else. It was simply to work towards how do we grant law enforcement in Georgia access to DHS, ICE databases, fingerprint databases. Because let me just make sure that the committee understands, and I will be succinct. When we run someone through the Law Enforcement Support Center, and we're talking about someone who is in custody who has committed a crime against a citizen or the state of Georgia, that's all we're talking about. They're in custody. They're in a jail somewhere in the state of Georgia. We run that by basically name and date of birth. Oftentimes that is provided by the person who's been arrested or by documents they may have on their person. Sometimes those documents can be fictitious. Regardless of the circumstances, we see false IDs from every segment of society, right? We run that based on that information. If that person, by that name and date of birth, has had interaction with DHS ICE, we get something back. If they haven't, or that name and date of birth has had no interaction with DHS ICE, we get back nothing. It says unknown. We don't know who this person is. Well, if you're part of 287G, which is rare and very few places in Georgia are, there was another group called Secured Communities that DHS offered. Secured Communities allowed us access. My sheriff's office was part of that, Forsyth County was, and many others were. We could then, when we fingerprinted somebody, one went to what's called the FBI, DOJ, criminal justice system. So we looked to see that they have a criminal history, had they been arrested in the United States, right? And that's for anybody. We do that for anyone arrested. Secondly, if it went to Secured Communities, it went to the DHS database to tell us that maybe they haven't been arrested in the United States, but there had been a DHS ICE contact, right? Maybe they had been, in a case of an illegal alien, had been deported or not. DHS would not even have a phone conversation with us about that. So make no doubt, Georgia sheriffs are working their tails off to remove dangerous people who commit crimes in Georgia. But understand where the problem lies, where the big problem lies, and that is that. So we'll continue. I would encourage this committee and our state to employ our federal elected officials and our federal partners. And I will end with this. I have to say this. When we work locally with DHS ICE, those are dedicated, hardworking individuals who do everything they can, but their dictates come from Washington, D.C. That's not about politics. That's about the challenges that they face and we face in working together. They work well with us, and they're esteemed law enforcement officers. So I don't want to disparage them in any way. So with that, thank you for working with us.
Yeah, and we got one question for you from Senator Jackson, if you would.
Yes, thank you. You mentioned that there are very few counties that operate with a 287G. Can you speak to why, or in your estimation, you don't speak for all counties,
Yes, ma'am.
but can you speak to why they don't have those programs, and if this Immigrant Responsibility Act of 1996 is less onerous or gives you more opportunities?
So I will tell you, I have personal experience. In 2018, I believe it was 18, it could have been 19, ma'am, I met with DHS and with Forsyth County. We talked about 287G. The federal government has some parameters, at least at that time. I cannot comment as to today, but I've been told by other sheriffs that it continues. I didn't have the numbers that we interacted with that were determined to be criminal illegal aliens who had committed crimes in the state of Georgia. So my numbers were really low in Forsyth County, even though we're 8th largest county in the state. We didn't meet the criteria for 287G. That's where Secured Communities came in, which just gave me another step, access to that fingerprint database. Secured Communities is dead. DHS has cut that program, and most sheriffs in the state of Georgia do not have access to that fingerprint database.
All right, thank you. Sheriff Freeman, before you go, I want to thank you for your leadership for the citizens of Forsyth, as well as your work on the board for the Georgia Sheriff's Association. I know there were a lot of sheriffs here yesterday also, and you came back to speak on their behalf. We also have members of our state police here, and we're going to take a moment of personal privilege and thank you all publicly.
Thank you. Thank you, Chairman. Thank you for your time, ladies and gentlemen.
Thank you. All right. We have got 10 people signed up to speak against this bill. Is everybody wanting to have their time? Because if so, we're going to go a little over a minute each. If not, we're going to see if anybody wants to combine their time. So speak now if you're going to combine your time with someone else. Okay, seeing none, we're going to start the shot clock.
Sorry, Chairman.
Yes.
The last two names are me and Michaela. We have the same question. And Maisie Lynn.
Okay, these are not questions at this point. There's going to be testimony, so you can come up and you speak.
Yes, it is testimony.
Okay.
Yes.
All right.
Yes.
All right, so I look like I've got Meredith Yoon. Please come up. Come to the podium, please.
Thank you. Good evening. My name is Meredith Yoon. I'm an attorney with Asian Americans Advancing Justice. There are a number of issues with this bill. I'm going to focus on Section 5, starting with lines 112 to 115. These provisions are overbroad and burdensome. As written, they would require a number of local agencies, potentially including all local government agencies, as well as law enforcement and prosecutors, to apply annually for memorandums of understanding with the U.S. government to enforce federal immigration laws. While some of these agencies may not be eligible for programs like 287G, the law would nevertheless place a significant burden on agencies that would need to assess every year what action is required on their part, as federal programs are subject to change and new federal programs are created. This would implicate a large number of local government offices and strain local government's administrative resources. Next, I'd turn to lines 127 to 128. This language seems to suggest that the existence of an immigration detainer or immigration warrant would itself authorize such transfers being carried out by local law enforcement to federal detention facilities, but that is not the case. Federal immigration detainers do not evidence any finding of probable cause that a person is a non-citizen subject to removal. Federal immigration warrants are not judicial warrants signed by a judge upon a finding of probable cause. Local law enforcement agencies will face potential civil liability for unlawful seizures, including unlawfully prolonged seizures that are carried out as a result of misleading language in the statute. Finally, I turn to lines 139 to 147. These provisions, which require local governing bodies to exercise control over sheriffs or else potentially lose state or state-administered federal funds, are vague and likely unenforceable. Memorandums of agreement for a jail-based cooperation program with ICE typically would be between ICE and the county sheriff.
Meredith, you're using up everybody else's time, hon.
All right, I'll wrap this up. So it's not clear for purposes of this proposed legislation what local governing bodies would have jurisdiction over the sheriff. Thus, local governments would risk losing funds for failing to enforce something which they lack power to enforce. Funds for needed public resources such as libraries, infrastructure, and mental health. We strongly oppose HB 1105. Thank you.
Thank you. Laura, come on down. Rivera and Catherine, you're going to be on deck, please. All right, remember, 1 minute, otherwise we're going to get everybody down to 30 seconds toward the end.
Good afternoon. I'm here to focus on a constitutional problem in Section 8. Lines 197 to 199 would require custodial authorities to fulfill any request made in the immigration detainer notice, and if they have a policy that contravenes this, under Section 6, it's a misdemeanor offense. This mandate to jail every person with an ICE detainer exposes localities to lawsuits for money damages for violations of the federal Fourth Amendment. That requires a warrant supported by probable cause, a touchstone of the Fourth Amendment, as my colleague said. That requires a finding by a neutral magistrate that the facts establish probable cause. Detainers don't guarantee probable cause because no neutral magistrate reviews them. Instead, ICE agents issue these documents themselves. It's like police signing their own warrant applications. So regardless of what choice police make to detain or not to detain, they're facing legal liability and increased costs. Thank you.
Thank you very much for your testimony, Catherine. And then, I'm going to probably get your name wrong. I'm sorry. Amilcar? Next up on deck after that. Go ahead, Catherine.
Thank you, Mr. Chairman. My name is Catherine Jerry Tranter, and I'm a political associate with the Georgia Latino Alliance for Human Rights. Today, we urge you to reject HB 1105. We were outside this building yesterday morning with community members from across the state protesting this very kind of bill. Georgians have sent over 5,000 letters to you, senators, and last week, we handed in this petition with over 7,000 signatures opposing HB 1105. We've also distributed to you today more data from the report that the sponsor mentioned yesterday. This is to give you full context of the actual crisis of violent crimes occurring in Georgia, and that only 2.1% of Georgia inmates are Hispanic, and actually 53.2% are white, according to the Georgia Department of Corrections. So we ask you to look at the whole picture instead of targeting minority groups to tackle this public safety issue. We also circulated a report conducted by Emory University with you, which explores the severe mental health consequences that anti-immigrant tactics are having on Latinx youth. They cite the border, 287G, and ICE raids as major contributors to mental health issues in the community. Syracuse University also reported that based on ICE data from 2008 to 2012, 834...
Catherine, you're using everybody else's time now.
All right, thank you. We strongly urge you to oppose HB 1105. Georgians have told you what they want. All you have to do is listen. Thank you.
Thank you for your testimony. All right, and then on deck's going to be Mark and then David, please.
Good afternoon. Thank you so much. My name is Amilcar Valencia. I'm the director of El Refugio, an organization that supports people who are in deportation proceedings at Stewart Detention Center. I have been visiting people who are in a detention center for a long time, and during these 13 years of service, I have heard that many of them are detained under 287G programs in some localities, simply for a misdemeanor, sometimes detained because of no license or other minor violations. We have listened countless of stories of children who have never got to see their dads again because they were taken away while they were going to work. We often hear politicians speak out of the state's economy and the growth and forget to mention that that is built at the back of the immigrant community. Simply put, they see the value in us because benefits them, but meanwhile, they do everything they can to deny our existence and our contributions to the state of Georgia. Many people are forced to leave their homelands. Many are victims of violence. Some are victims of human trafficking. Some have to leave because of their faith, their identity, or their political positions. And they are already been traumatized and continue to be re-traumatized in immigration detention facilities.
All right, we're going to have to wrap up, please.
We are strongly opposed to this bill and hope that you take into consideration that we're talking about people with life. We're talking about a whole community that is being affected. And please say no to HB 1105.
Thank you for your testimony. Councilman Mark Perkins, please come down. Good to see you.
Hey, good to see you too, Mr. Chairman. Thank you to all of you for the hard work you do representing us at a municipal level. So my concern with this bill is its impact on smaller cities. I represent Clarkston at the municipal level, and one of our challenges is recruiting officers, officer retention, just because we're a smaller city with limited resources. As I look at some of the provisions of this bill, our officers are hard at work protecting our community, and this pulls them away from enforcing actual crime that impacts folks into an immigration role, which is a concern for myself. Really, it comes down to the additional administrative burden on our departments. We have unfilled positions as it is, even though our department, our chief is working incredibly hard to fill those positions. So I encourage you to reject this bill in its current form. Thank you.
Thank you for your testimony. And the first person to stick to the timeline. David, come on down.
Hey, good afternoon, Mr. Chairman. Thanks for the opportunity to make a couple of comments. My name is David Schaefer. I'm the VP of Research and Policy at Georgia Budget and Policy Institute. Wanted to lift up a couple of numbers in terms of cost as to what this bill could cost. Based on past data in 287G jurisdictions between 2008 and 2017, we think this bill could cost across the state of Georgia about $11.2 million on a yearly basis. We're fearful that a lot of those costs would not be reimbursed by the federal government. In fact, historically, reimbursements for those kinds of costs from the feds have been very low. For larger counties, we could be looking at expenses as high as $1.5 million to $5 million on an annual basis. We're talking about a large county that is enforcing what is in this bill at scale. So I just wanted to lift up those cost concerns to you, and for those reasons, and I agree with the other comments that have preceded, we are against this bill. Thank you.
Thank you, David, and again for sticking to the time. Darlene, are you going to waive your time to Maisie? No? Okay, come on down. Darlene, and then we've got Michaela on deck.
Thank you, Chairman. Thank you, Committee. My name's Darlene Lynch. I'm a lawyer with the Center for Victims of Torture. We work in the refugee and immigrant community. I'm here today on behalf of two coalitions, the Coalition of Refugee Service Agencies, the oldest and largest coalition working with refugees and immigrants in Georgia, and the Big Partnership, a statewide partnership of business and nonprofit leaders seeking to strengthen the economy by tapping the talent in our refugee and immigrant communities. I just want to make 2 points. The first one is about the key role that foreign-born Georgians play in our economy, particularly during the current workforce crisis. 1 in 10 Georgians is foreign-born. That's 1 million people. But 1 in 7 Georgia workers is foreign-born. 1 in 5 small business owners, and 1 in 4 physicians, particularly those working in underserved and rural areas, are coming from our immigrant communities. I know that the authors suggested that this bill would only hurt immigrants who commit crimes and that it hasn't changed much. But as someone said earlier, when you change mays into shalls, you change this bill, this law. When you add draconian penalties, you change this law. So under existing law, I'm going to refer to page
You're
5.
You're already over time, so you're going to have to figure out how to wrap this up.
Last sentence.
All right.
Page 5, Section 5, officers have immunity if they try to enforce this law and impact someone who is here legally. But what they risk if they don't, let me just get this straight. But if they are not as aggressive enough, then they risk depriving their whole county of funds and facing criminal penalties. So the choice is clear. They get immunity if they're aggressive. They get severe penalties if they're not. That's how it's going to affect all foreign-born Georgians.
Thank you, Darlene. I appreciate your testimony. I think you'll find later that some of that was adjusted to cure some of the concerns from our sheriff's organizations. Michaela, please.
Hi, good afternoon. My name is Michaela Arciaga. I work in education policy, so I know some of you know me from that space. I'm here in my personal capacity. I just wanted to raise a couple of concerns about your definition around local governing body and maybe some unintended impacts, particularly as it pertains to school-based police departments. So as many of you know, many of our school districts around the state have their own in-house school police departments. You may not know that we have federal Supreme Court cases that protect the rights of students regardless of their documentation status. Plyler v. Doe protects students even if they commit a small crime or a misdemeanor and are being held. Public schools in their districts are not allowed to treat a student differently to determine their documentation status. They are not required, they are not allowed to require students or parents to disclose their documentation status, and they are not allowed to make inquiries of students or parents with the intention to expose their documentation status. I personally do not support this bill, but I also think you're going to have some unintended impacts putting some of your officers and in conflict with federal and state law if you continue with this bill. Thank you.
Thank you for your testimony, Michaela. Okay. Maisie, are you going to take Isabel's time? Is that right?
I hope I don't need it. I
That's-
might be able to do this in a minute.
All right,
We'll
let's
see.
go.
Despite significant improvements in House Bill 1105 since it passed out of the House, we continue to be gravely concerned about the impact of this legislation. Yesterday, Immigration Attorney Jessica Stern was here to offer input on yesterday's version and spoke with Representative Petrie after the hearing. Unfortunately, she can't be here today. She and I have known each other since we began practicing 15 years ago as public defenders, so given the fact that her concerns are closely aligned with GACTL's, I agreed to bring that to your attention today. She left the public defender office and added immigration law as a complement to her criminal defense practice, and it really is an expert in this field. In addition to speaking with Representative Petrie, she provided written suggestions and potential edits via email late last night or early this morning, depending on how you perceive time. I understand that Representative Petrie acknowledged her suggestions, but just doesn't have the capacity in this moment to review them, but has agreed to look at them this weekend. We really do appreciate your willingness to take her suggestions under consideration, Representative Petrie. Look forward to further discussion. And if there's any interest from the committee in those suggestions, I'm sure she'd be willing to share them more broadly, but didn't want to do that before discussing them with him. Unfortunately, the version that you're considering here today raises new and some nuanced differences that continue to expose officers on the street to prosecution who are policing our communities. The implications on the 287G and the MOU provision are concerned to us, and the structure of the 48-hour detention requirement that's been modified also concerns us. None of these can be effectively fleshed out in 1 minute. We're hopeful that further work on the language, including discussion of Ms. Stern's suggestions once reviewed, could result in a bill that more of those impacted by it could support.
Thank you so much, Maisel, and I appreciate your time today and your testimony. All right, we have concluded the part of those speaking against the bill. We've got 3 people signed up for, so we're going to do 5 minutes each. We're going to give deference first to Representative Martinez. You want to come up to the podium, and we would love to hear from you.
Thank you so much, Chairman and committee. So my name is Ray Martinez. I'm one of the few Hispanic elected officials in the other house. I was so proud to vote for this bill, 1105, and I support my great colleague, Representative Petrie. Mr. Chairman, this is not about immigration. As you know, I'm Latino. My parents left Cuba, and I was born in Puerto Rico, so I am a product of immigration. This is, to me, is about public safety. It is about public safety. Like we talked about in the House last week, this is not about politics either. My good friend has been working on this for a number of years now, even before this tragic accident of our student, Laken Riley. I had this is sad to meet the parents this past weekend of Laken Riley, this past Saturday. And I hear about money, cost, how much this thing's going to cost. Tell that to the parents of Laken Riley that just lost a daughter. I'm going to mention a couple names to you. Kate Steinley, Laken Riley, Lennox Lake, Sheila Estes, Ronald Del Silvia. These are people, these are victims of illegal immigrants that came to this country illegally. And not only that, they came up here committing crimes. And before they committed these crimes, they already had a record. And because of policies of some of the politicians and cities, we had a few that fell to victims. I'm going to, very briefly, I'm going to name a couple numbers to you. In 2024, so far this year, we've had 9,058 encounters by China in the southern border. Out of those encounters, 8,074 are single adults. I wonder what those adults are up to. We don't know. We can only guess. In 2023, Custom Patrol, Border Patrols arrested 35,433 illegals with criminals convictions. 35,000 illegal criminals, and they were convicted, including 598 gang members. Out of those, 178 are MS-13 members. You know what they're up to. In 2023, Custom Border Patrols has seized, this is very important, over 27,000 pounds of fentanyl in our southern border. Enough to kill many Americans. 2024, so far this year, there's been 169 members apprehended in the border from the terrorist watch list. Wonder what they're up to. We don't know that. Were apprehended. This is the problem, and I'm so glad that my good friend, Representative Petrie, introduced this bill. I'm so proud of what he did. And I'm going to say one last thing before this is a big problem. In 2023, over 2019, encounters at the border have increased over 100% from 2023 to 2019. We have to, as a Latino American, we have to get a hold of this, because at the end of the day, it is not about immigration, it's about public safety. Thank you, Chairman, for your time.
Thank you, Representative, and right on time. I appreciate that. D.A. King, come on down to the podium. We'll reset the clock here.
Thank you, Mr. Chairman. My name is D.A. King. I am president of the Dustin Inman Society. Mr. Chairman, I had a handout. I don't see that it's gone around. Could I get that taken care of, please, sir?
I don't believe we have a handout. Oh, okay. All right, we'll take.
So the Dustin Inman Society is a 501c3 IRS nonprofit. We were formed in 2005. The Dustin Inman Society is named after a young man from Woodstock, Georgia, who will always, forever, be 16 years old because this country does not enforce our immigration laws. Dustin Inman was killed when an illegal alien ran into the back of the family car on Father's Day weekend, the year 2000, when they were stopped at a light. The wreck killed Dustin Inman immediately. It killed the family dog in the back seat with Dustin. It put his parents in a coma. And when they woke up, they were told, your only child is gone and you missed the funeral. That crash was a direct result of years of suffering for Kathy Inman, Dustin's mom, who spent the rest of her life, which was 20 years, in a wheelchair. She eventually died as a direct result of her injuries in that crash. Her husband died the year before from the strain of trying to find Dustin's killer, who is now in Mexico. The State Department cannot bring him back because Mexico doesn't have a similar charge that he was arraigned on. So if we're going to mention names, Dustin Inman, Kathy Inman, Billy Inman, the Inman family is wiped out. The illegal alien who ran into the back of their car had been stopped not once, not twice, but 3 separate times by local police and released. I've been working for a very long time trying to educate people on the consequences of illegal immigration. It's not a victimless crime. For the last 6 years, I have been asking questions and trying to create some action on the 2 of the laws in this bill, 42414 and 368023. I was here on this campus and worked on the formation of those laws, one in 2006 and the other in 2009 and 2010. I can never remember. In 2006, we put in place a law that says that jailers, mostly sheriffs, are supposed to use a reasonable effort to check the immigration status of incoming foreign-born prisoners, mostly through documents on their person if they can't determine immigration status, then to check with LASC, NCIC, or ICE. When I realized this law was not being enforced, I started talking to the Sheriff's Association. And when I realized after several years that that was getting me nowhere, I was told, DA, there's no penalty. Then I started talking to news media outlets. That also got me nowhere. Then I started talking to legislators, and I want to stand here and use at least 10 seconds of my time to thank from the bottom of my heart my now friend, State Representative Jesse Petrie, for taking it upon himself to pick up what before the horrible death in Athens was not that popular of an issue. There's a reason that there wasn't a protest outside yesterday or the day before from the hundreds of thousands and millions of Georgians who on the pro-enforcement side of this very horrible issue. And it is an immigration issue. I'll disagree with anybody who says it's not an immigration issue. It is. Our world is different because the United States does not secure our borders, and now because law enforcement officers in Georgia, quite frankly, have ignored the laws we put on the books in good faith in 2006. But the reason you don't have rallies and protests outside from the millions of Georgians who are on the pro-enforcement side is because they assume that the laws the state puts on the books to address this issue and pretty much all other issues are going to be enforced. I'm hopeful that we can put some penalties in the law so that it is actually enforced. I would like to take a few seconds to make it clear that the added language that relieves part of or adds a degree of difficulty to prosecuting wayward jailers for knowingly and willfully ignoring this law or not being in compliance, it strains credibility for us to realize that we have to obey our tax laws, our seatbelt laws, don't touch the iPhone, but a jailer can somehow decrease the possibility of being convicted of ignoring by the degree of knowingly and willfully. So I'm hopeful that at least on the second offense, you could consider taking that knowingly and willingly out of the existing sub. I hope I didn't go over. I thank you for your time. I've got about 100 more things to say.
Thank you very much for your testimony, DA. Next, Mr. Taylor Hawkins with Frontline Policy. And right after that, we're going to hear from Representative Houston Gaines.
Thank you, Mr. Chairman, members of the committee. My name is Taylor Hawkins. I'm the Director of Advocacy for Frontline Policy Council. Our organization is built around dedicated to protecting a state where families thrive, life is cherished, and freedom flourishes. And our organization fully supports 1105 because of how it sets up our state to solve an issue before us. I want to echo the words of the Sheriff's Association speaker in recognition of the incredible work done by so many sheriffs and so many officers across the state of Georgia. You'll find very few people, even in this building, who are more pro-law enforcement than I am. But our state is facing an extremely dangerous issue. It's one that's being felt across our nation, and it's one that this legislature is acting to address in a measured and positive fashion with this legislation. The issue is that while illegal immigration is on the rise, a very few in public office have failed to affirm the most basic public safety principle, that law enforcement should do their utmost to protect our citizens from those in any population who commit crimes against the laws and citizens of our state. They do this in the name of protecting minorities, which is absurd, both to claim that criminals represent any community, as well as to claim racism in response to enforcing basic federal immigration standards, which do not see color and applies to those from any country. Foreign-born Georgians, certain ethnic minorities, and immigrants were all mentioned by the opposition, which is interesting because this bill actually does not address any of those groups. This bill addresses criminals who are in our nation illegally, and specifically addresses law enforcement behavior around those criminals. The job that law enforcement does, again, is incredibly important, and we are so grateful for the men and women who serve our communities across this state. The problem is clear. A select few have campaigned on, got elected on, and run their agencies based on the rhetoric of promising not to fully enforce the laws of our state and our nation against those who are in this country illegally and who commit crimes. I want to emphasize that. We're talking about those who've committed crimes. Those few public officials are betraying the public trust they have been given. They're endangering their communities in order to secure a few political points and are not representative of the vast majority of honorable men and women in law enforcement across our state who are doing their job. They're working with the appropriate agencies, and they are fulfilling their duty to protect citizens and families from rogue criminals. This bill before you is a targeted approach to address those specific bad actors and use the tools this state has to prevent craven political agendas leading to the victimization and loss of life of Georgia citizens. House Bill 1105 provides clarity on procedures for verifying immigration status, establishes protocols for cooperation between local and federal agencies, and then imposes penalties for noncompliance. This is not a shoot-from-the-hip approach by any means. It is the result of years of measured work by Chairman Petrie, House leadership, and many in this building to solve a very specific problem with a very specific solution. And it does not attack the brave folks in blue who put their lives at risk to serve our communities. We're confident that this measure will go far to protect families and prevent them from suffering the same tragedy the Riley family has in the wake of Lakin's brutal attack. An attack, by the way, that was fully preventable and would not have happened had this bill been in place. You heard the names from some of those victims from my friend Representative Martinez earlier. These are American citizens who should not have lost their lives. And with this bill, that list of names will hopefully stop growing in the state of Georgia. It's for these reasons, Mr. Chairman, that I offer Frontline Policy's full support of the measure before you and ask you to pass House Bill 1105. Thank you for the time.
Thank you, Taylor. Appreciate that. And Representative Gaines, I'd like to have you come down here with Representative Petrie, if you wouldn't mind, as you help to add some language to the bill. And I want to give you an opportunity first to just address the bill overall, and then we're going to get into the changes with the bill's author. Please go ahead.
Well, thank you, and certainly just want to thank Chairman Petrie and you, Chairman Albers, for your work on this important bill. I think it's the most important bill we're going to consider this session. And, for somebody who's born and raised in Athens, went to the University of Georgia 3 weeks ago, obviously we just had the most horrific thing happen in our community. Laken Riley, a 22-year-old nursing student who just had her full life ahead of her. And, first and foremost, I think it's most important we keep the Riley family in our thoughts and our prayers. And we all know that as we learn more and more about what happened, how many times this young woman was failed. We know the southern border is a disaster. What our federal government's doing hasn't worked. But we also have local governments that have failed us, and we have issues that we have to address. And certainly I think House Bill 1105 is a really important step forward to make sure we address some of the gaps in law that we need to make sure that local governments and local sheriffs and those who are in charge of making sure that we comply with the law, that we address the gaps and make sure that what 1105 does is what's already the law, making dang sure it actually happens, and that when you have someone who's in the jails, that they're being reported to the federal authorities. The individual who committed this heinous crime in Athens had multiple run-ins with law enforcement. Obviously at the border, was apprehended and released, was arrested in New York and released, and had been cited for shoplifting in Athens in October, had an active bench warrant for his arrest from December 20th of last year. And his brother had been arrested 3 times in Athens, including for DUI and other charges. So there were multiple run-ins with law enforcement. There were many times where this young woman was failed, and that's what certainly I think House Bill 1105 addresses those. Chairman Petrie's been working on this issue for years, and so certainly I want to thank him for his leadership, and I want to thank you, Chairman Albers, for your work on this bill. So thank you.
I appreciate your testimony. Obviously, you represent a good portion of the Athens community, and Lakin Riley and her parents I represent. So thank you for being a part of this. Back to the bill's author, Representative Petrie. Why don't we go through the changes that are in the current substitute? This was emailed to the committee members a little bit earlier today, and this addresses some concerns before you go through the specifics. We have met, actually a group of us have met, obviously with the Sheriff's Association. We had many individual meetings with other stakeholders and folks that wanted to give us some feedback on that. I think the changes got us to a point where a lot of people, it eased their concerns, but still kept in the parameters that we thought were important. So with that, why don't you just take us through the changes? We do not need to go through the bill again because we did that yesterday.
Yes, sir. And do you want me to address all the changes, Mr. Chairman, or the?
I think you can just go kind of a high level as
Yes,
to
sir.
where they are.
Okay, so the major changes, Mr. Chairman, are on the section that deals with local government officers, where we have it shall be unlawful for those individuals. Well, let me go to that. I'm sorry.
While he's finding the section, one of the
Yes.
pieces of feedback that Terry Norris and his leadership team found was we have sheriffs who have jails that they are responsible for. They are constitutional officers. We also have, in some cases, jails that are at the city municipal level, and we needed to call those out separately in the code because those are separate areas. Thank you, Terry and team, for bringing that forward.
Yes, sir. There was some good, I think, language to differentiate that we have a multitude of jailers, not just our jailer sheriffs. So that's in here. Mr. Chairman, on line 165 is the one I just alluded to. I've now found it, where we speak to the provision and the penalty regarding
knowingly and
local,
willingly.
local, I'm trying to see it here. Local governing bodies and officers of local governing bodies. We have knowingly and willfully entered there. You'll see on line 165.
And that is repeated again, I believe, in lines 316 to 318.
And that is, yes, sir, and that's where I was going to go next. The custodial authority on line 189 to 192. Everyone may note that we've got a definition there of custodial authority to make it clear, again, to the point raised earlier, that we're speaking to that person in control of that particular jail. It may be a county jail or a municipal jail. That differentiation we alluded to earlier is in there. And then on line 197, you'll see it, as it relates to that, any custodial authority who has custody of a person who is subject to an immigration detainer notice shall comply, honor, and fulfill that request. So we're saying the same thing, but with, I think, some improved language, Mr. Chairman. And then you just alluded to the sheriff's line, which would be on line 288. Mr. Chairman, where we say again, it shall be unlawful for any jailer to knowingly and willfully violate any provision of this code section. That is always what the intention was, but if that, obviously we made it clear yesterday, very clear. Our goal is to capture folks that have made it clear they're not going to follow Georgia law and have a history of not doing so. And we never intended to capture anyone more than that. If this makes folks feel more comfortable, that has been inserted on line 288. And we, on section 11, Mr. Chairman, line 320, there is a section that Representative Gaines and I have added, with your permission, which speaks to the Attorney General and his authority to prosecute someone who also, we also have a route to prosecute some of these individuals who are failing to fulfill the law as well.
And that
So
could
we've
be the
added that.
local district attorney's office or the attorney general, so both would be.
Or the
in
Attorney
play.
General. And so
Excellent.
we've added that language there all the way down through line 343, Mr. Chairman. And I think that is the meat of the changes there, Mr. Chairman.
Thank you. I definitely appreciate the work, and I just want to take a moment for the committee and for the folks that are here today, and I know there are some people watching online. We worked very hard on this bill over the last week and a half. We got a lot of input, very thoughtful. I will tell you, there are some people that think it's not going to, or not gone far enough, and we've got some people that think the opposite. We tried to craft something in the middle, and I, for one, and I know you gentlemen do too, believe that word compromise is not a dirty word. It's a good word, and we should do it more often in order to get consensus. I think this is a very well-balanced bill. I want to thank you for your help on that. At the appropriate time, there are two amendments that are going to be offered. One is a Scrivener's error that I will tell you all about right now, and it's going to be between lines 273 and 274, where it says an arrest warrant issued by, that actually from where it's the United States to the next line, Homeland Security, should actually be a federal judge or federal magistrate judge. Is that correct, Jenna? A federal magistrate, I'm sorry. That's going to be where it's going to happen. So that is one area because those folks cannot take out warrants. And then there will be another amendment that's going to be offered by Senator Bearden, and I'm going to let him bring his amendment up after that as well. So I just want to tell everybody what's going to happen here. We're going to do any final questions to the bill's author at this time. All right, seeing none, what's the will of the, oh, you have a question.
Yeah, thank you, Mr. Chairman. So I would like for you to speak to one of the issues that was raised in the testimony as it relates to the Fourth Amendment rights, potential violation by holding these detainers. Can you just speak to how we make sure that our law enforcement officers are not open to or subject to lawsuits by detaining people without probable cause?
Yeah,
based on the detainer?
so Senator, thank you for the good question. What I can tell you is this. So you have recent, and I know we can't look that up now. If you will look at recent decisions in Florida and Texas, you will see that provisions like this have been upheld by federal courts. Florida and Texas.
So you're saying that this type of language that we have is in law in Florida and has been litigated without?
The issue you're addressing has been addressed in Florida and Texas and has been upheld. Yes, ma'am. We looked into that.
And
We looked into that quite well early on.
may I
Yes,
follow
ma'am.
up?
Yes.
Additional question. So some issues also raised were around the distinction in who has authority when it comes to a county and the sheriff's office. So in my county, Sheriff Maddox is a elected official. She's her own.
Sure.
She's her own thing. And so if Sheriff Maddox were to not follow this code sections, if it were to become a law, the punishment that's exacted is not on just the sheriff's office. Now, she'd get charged with a misdemeanor if she was willfully knowingly, but my county commissioners and my county would be penalized, even though my county commissioners have no authority over the sheriff. And so can you just speak to how we come to peace with the fact that the actions of one independent office would have an impact on the entire county when they actually don't have authority over that person?
Well, I think the language is, let's find it on here.
I believe we corrected some of this with the help with our Sheriff's Association as well.
Yeah,
in
we
order
went
to
around and
alleviate
around getting the
their
language right.
concerns.
The goal is the governing body of the law enforcement agency. And in the case of a sheriff, as a constitutional officer, they are their own governing body. But we have addressed this and discussed it. And that is the answer to your question, sir. What was that? Line 145, okay.
It is a good question, Senator Jackson. This was brought to our attention a couple of days ago, and I believe in the work that we had done, we've addressed that in the language now.
So then what we're left with is that in the event that a sheriff does not comply with this section, the police department itself would become defunded by the state.
They could
That's what we're-
withhold state or federal funding. You cannot withhold dollars necessary from a local sheriff police department because they are funded by local taxes. But if they
Okay.
receive additional state or federal
State or
funding,
federal.
then that could be impacted.
The things you,
All right.
you call luxury ones.
All right. Okay, let's get back to the bill at hand here. I'm going to begin with a motion on the overall bill, then we'll talk about the amendments. What's the will of the committee? I got a motion to pass from Senator Williams. Do I have a second? A second from Senator Bearden. Now I'll be entertaining motions. Let's begin with the one we discussed. Jenna, would you make sure we have the correct location on line 273 and 274, please?
Yes, so on line 273, replace the United States Immigration and Customs Enforcement Division of the Department of Homeland Security with a federal judge or a federal magistrate.
All right, did everybody in the committee hear that? We're going to replace that section with a federal judge or magistrate. Everybody heard that? Okay. Does anybody want to make that as a motion to an amendment? I have a motion from Senator Payne, a second from Senator Williams. All in favor of amendment number 1, please raise your hand. All opposed? Amendment 1 passed unanimously. Now, in your folders, Senator Bearden has a pre-prepared amendment by Legislative Council, and I'm going to recognize you to share your amendment.
Thank you, Mr. Chairman. Hey, Mr. Chairman, I appreciate you taking the time to talk to me yesterday after the meeting and again this morning. Me and the author talked about this amendment, and he said he was supportive of it. It was a relatively new amendment. As you can tell, we don't have the LC number in there, so if we just get to the meat of it.
We can, and this is Amendment 390408, and you can just go down to the area that makes changes, which I believe is on page 2.
Yeah, on page 2, it's going to make a change to Code Section 35-3-160. As you remember yesterday, Chairman Petrie gave us a list of crimes that were committed and people that were in the jails currently. A lot of those were like child molestation, rape, murder. A fingerprint will not always be attainable at these crime scenes, but DNA and with the progress we made with DNA can be. So if you look on line 29, all this amendment says is who has been convicted of a felony or misdemeanor and is subject to an immigration detainer notice as such term is defined in Code Section 42-4-16, we will get a DNA swab and have that DNA put into the database. Because if they're released or there's an unsolved crime out there and there's DNA evidence, we will make sure justice is brought to our citizens.
And this is just for somebody who has been convicted. I want to make sure we're all clear on that. Okay.
Mr. Chairman, what line was that again? And that's on the new.
This is on the, do you have the
LC?
amendment?
This is the amendment. No, I don't have the amendment.
Okay,
What
why don't
line
we,
is it being
you're going to get a
inserted
copy
into?
here.
That's the line on the amendment, that's line
Okay.
29. I'm
Oh,
going to need
on line-
assistance.
okay,
I'm
thank
going to
you.
need assistance from Legislative
I got
Council
you.
to
Thank you.
where it
Thank you.
officially goes. I feel like it may go to Section 8, but I dare not get in front of Legislative Council.
You got one?
All right, we're going to discuss the amendment, then we'll
Very
ask
wise.
Jenna of the Legislative Council to tell us exactly where this is going to be inserted if the amendment does in fact pass. Are there questions for Senator Bearden? Okay, I have a question from Senator Jackson.
Yes, I'm sorry, I'm just catching up, sir. So I just, Senator Bill, I just want to make sure I understand your amendment here. So your goal here is that if someone is arrested and convicted of either a misdemeanor or a felony, both, right? So it's not just child molestation, but of any misdemeanor or felony. If they're convicted of it and they are determined to have an immigration detainer, so that doesn't mean that they've been determined to actually be here illegally. Just by having the detainer itself, you're saying that we will now collect their DNA. Is that what you're saying?
It's subject to a immigration detainer, correct. We will take that DNA.
So I think a couple of things I'm concerned about. One, having a detainer is not evidence, is not proof that you are actually here illegally. And so, I mean, any number of people could have a detainer. There's a process this goes through. So I get and I appreciate that you require a conviction before getting DNA as it relates to the underlying felony or misdemeanor, but I'm concerned that you're requiring this before the underlying issue in terms of their immigration status is fully adjudicated. That's very concerning to me. And then the additional piece to this is I also understand why we would want to collect DNA for somebody who's been convicted of rape or of some type of heinous crime like that. A misdemeanor conviction could simply be a tail light being out, right? I mean, it could be a traffic violation. Those are misdemeanors in the state of Georgia. So you're saying to me that someone who gets a traffic violation and is convicted for it, who happens to have a detainer, who we do not know if they're here illegally or not yet, would have to give their DNA.
And what we're saying is if they're convicted of a felony or misdemeanor and subject to that detainer, yes, because we don't want someone leaving or maybe been convicted of a misdemeanor and go out in this country illegally and commit a heinous crime like we've seen throughout this country. And there's probably going to be unsolved crimes that will be solved because of this amendment right here if this bill goes forward and approved by the House and Senate. We cannot afford to have crimes of the nature that we've been seeing committed by illegal aliens in this country and in this state. And there's a way to stop that, and I do appreciate your concern.
Yeah.
And from a former law enforcement officer, knowing the strides we've taken in DNA, this could be such a meaningful piece of this bill. And again, very gracious to the author for allowing me to put this amendment in or offer the amendment. But we need to make sure that we do everything we can to help either on unsolved crimes or crimes we can't solve, and they can be solved through DNA.
Right, so but I want to be clear, we don't treat natural-born U.S. citizens who are convicted of misdemeanors in this way. We do not collect DNA samples from people who are convicted of misdemeanors. What your amendment would do is that those who have an immigration detainer but turn out to actually be here legally, now you are collecting DNA from them for a misdemeanor, which we don't treat people that way. We believe, I think this body believes that when you're convicted of a misdemeanor that you still have a right to privacy when it comes to your own DNA. That a misdemeanor in particular is not enough to necessitate the government having your biological material. That's what you're talking about us doing. And we don't do that to American citizens. A detainer does not prove somebody is here illegally. And so I am concerned that people who are completely innocent, who are here legally, are being treated differently and having their biological DNA collected by the government in a way that we would never do to someone who was naturally born here.
I believe that was a statement, not a question, so.
Right, okay, so appreciate that and trying to cut through that just a little bit if I can. If you look at this, I'm not aware, I'm sure there's one or two out there at some point or another that had an ICE detainer on them that were actually here legally, but most of the time there's a reason for that. And if someone did enter the country illegally, they already in fact have committed a crime. This is a convicted crime on top of a crime, and I believe that's how Senator Bearden is getting to the place that he wants to get to. So, all right, we're going to take a motion from Senator Bearden, and I'm going to add to this from Legislative Counsel that on line 2 that you see, it says matters the following. That's going to go to line 25. And then on 6, it's going to be between lines 408, 409, and it'll be section 12A and reordered as amended. So that's the way it's going to read, and this is Amendment 390408. It is being offered by Senator Bearden. Is there a second to the amendment?
I'll second.
Got a second from Senator Williams. Okay, all those in favor of Amendment 2, please raise your hand. 1, 2, 3, 4, 5. All opposed? 1, 2, 3. Passes 5-3. Okay, we have a new amended bill in front of us. Thank you, everyone, for your work, for your testimony, et cetera. I'm going to call the question at this time. All those in favor of passing the amended version of House Bill 1105, please raise your hand. 1, 2, 3, 4, 5. All those opposed? 3. Motion passes. Best of luck to you, Representative Petrie, in the Rules Committee, and I believe I'll be carrying that for you on the Senate floor. Thank you. Do I have a motion to adjourn?
Motion so moved.
I got a motion, a second. All in favor, please say aye.
Aye.
All opposed, no. This meeting is hereby adjourned. We will be meeting next Wednesday. Thank you.